My name is Amir Aziz and I'm here to present my assignment and our topic is, we choose our topic is Road and Traffic Authority versus Dederar. And in the start, in brief introduction, the High Court upheld the RTA's appeal in overturning the New South Wales Court of Appeal judgment in relation to 14-year-old plaintiff who was rendered partially paraplegic when he was dived off a bridge, Foster, New South Wales. Right. The facts of this case are the plaintiff was a 14-year-old boy who lived off Forester Tanqueray Bridge and was rendered as paraplegic. Right. The area was a popular tourist destination, and for many years, young people had frequently jumped and sometimes died off the bridge into the estuary below. The plaintiff had spent holidays in the area since was a small boy and had frequently observed children and adults jumping and diving off the bridge. The plaintiff was aware that the area of the beach, the estuary, was very much given to tidal action. He knew that the depth of water dropped suddenly at the edge of the sandbar, and the water in the channel was very deep. He accepted that the depth of the water in the channels was hard to judge due to the flow of the water going under the bridge. Well, the plaintiff dived off the bridge and struck his head on a sandbar, which rendered him paraplegic. There was a pictograph signs at the approaches to the bridge prohibiting diving. The signs in words prohibiting climbing on the bridge. The plaintiff saw these signs and ignored them. Well, there was no previous accident in relation to diving from the bridge. When he was asked in evidence what the signing prohibiting diving conveyed to him, the plaintiff stated, "It just told me I shouldn't dive. I didn't put any danger into it." Well, the plaintiff sued both the RTA and the Greek Lakes Shire Council in negligence. Well, the decision of the trial judge. The decision of the trial judge, Judge Dunford in the Supreme Court, found both the RTA and council negligent. His Honour was satisfied that both defendants owed a duty of care to person jumping and diving off the bridge to warn them to danger of doing so. His Honour held it was not sufficient for the defendants to ignore the fact that the signs were being disregarded, and it was necessary to consider what if any further steps should reasonably have been taken by way of further warning signs, modification of bridge, or otherwise to prevent injury to persons such as plaintiff, or to put in another way the content of the duty of care. Well, His Honour held the RTA had breached its duty of care and was negligent in failing to erect a warning sign containing a similar to danger, shifting sands, variable depths, in failing to replacing existing handrail with one composed of vertical rather than horizontal members, and in failing to modify that flat top of the handrail so as to make it more difficult to stand on. His Honour also found there was 25% contributory negligence on the part of plaintiff. As the RTA had overall control of the bridge, the greater accesses to funds them from the connected to the bridge with the bridge had created the danger in the first place, and failed to modify the structure when no diving pictograph proved ineffective. His Honour apportioned 80% responsibility to the RTA and 20% to the council. Well, if we further discuss this case, the majority of the court appeal Handley and Tobias JJ agreeing held that the council exercises substantial degree of de facto control over the bridge and assumes responsibility for certain aspects of it. The council therefore owed a general duty of care class of persons, which included the plaintiff. Well, the court held the obvious risk provisions in Division 4 of the Civil Liability Act 2002, New South Wales, relieved the council of legal responsibility for the plaintiff's injuries, as the risk was obvious, and therefore the council's appeal succeeded. Well, what is the liability of the RTA? The liability of the RTA, basically the evidence indicated that the RTA was aware that young people were diving off the bridge. The serious risk of devastating injury must have been obvious to RTA.
3.
Well, we were on liability of the RTA. The evidence indicated that the RTA was aware that young people were diving off the bridge. The serious risk of devastating injury must have been obvious to RTA. The Court of Appeal per IPP and Tobias JJA held that the RTA ought to have known that pictograph signs prohibiting diving were ineffective. Many of the visitors of the bridge were young children, young people, and the RTA could not assume that they would take reasonable care for their own safety. The bridge constituted an allurement to young people to jump and dive off it. Accordingly, the standard of care which the RTA was required to exercise was higher than that required from authority that controlled land where natural features constituted a danger to the public. It was held per IPP and Tobias JJA that a sign which prohibited diving and expressly explained and emphasized the nature of the danger would have been more effective than the sign the RTA erected or the signs proposed by Dunford J. This also would have been an inexpensive. Well, my friend will explain further. Thank you.
Hi, my name is Dederar. My ID number is EAB2501. I'm going to discuss some of the High Court decision. The majority of the High Court, Gleason CJ and Kirby J, dissenting upheld the RTA's appeal. Gumrose J, who delivered the leading judgment, firstly affirmed the decision in Bodie versus Singleton Shire Council 2001-206 CLR 512 that the duty owed by a road authority was to exercise reasonable care so that the road was safe for users exercising reasonable care for their own safety. In applying these tests, His Honor held the RTA did not owe a more stringent obligation towards careless road users as compared with careful ones. In each case, the same obligation of reasonable care was owed, and the extent of that obligation was to be measured against a duty whose scope took into account the exercise of reasonable care by road users. His Honor emphasized that the obligation to exercise reasonable care must be concentrated with an obligation to prevent harm occurring the others. The fact that the RTA knew that people were not exercising reasonable care for their own safety in large numbers in diving off the bridge did not mean the RTA owed a duty to prevent them from going so. His Honor pointed out that if a contrary approach were taken, defendants would be liable in any case. In taken by the majority of the High Court was that the party who gave the warning could not necessarily be found to have been negligent by a reason of the warning having failed. The RTA did not control the plaintiff's voluntary action in diving, and nor did it create or control the natural variations in depth of water beneath the bridge. The risk injury arose from factors which were outside the RTA's control. This is not a case where the defendant had done nothing in response to forcible risk. The defendant had irrigated signs warning of and prohibiting the very conduct engaged in by the plaintiff.
30 seconds.
Thank you.
30 seconds.
Hello, my name is Raja Muzammil Arif, and I'm going to describe implication. The decision affirmed the approach taken by the High Court in Wyong Shire Council v. Short 1980 146 CLR 40, which was reaffirmed in Wyong Shire Council v. Wary 2005 225 CLR 422 that a breach of duty needs to be considered in light of what a reasonable person would have done to avoid the risk of injury. This approach emphasizes on whether the defendant's response to risk of injury was reasonable. The test is to be applied by asking prospectively what the exercise of reasonable care required in response to foreseeable risk of injury, not by focusing in the respective on how the defendant could have prevented the plaintiff from diving. The court has emphasized that emphasized that in implying the principle in Wyong short counsel with short, this criterion in reasonableness rather than a stringent requirement of prevention of injury. Thank you.